change that we made, significant change made from community feedback.
Okay. Some additional changes that you will see in the red line version of the new code. And Heidi, I think I might ask you just to go over this one again as well.
Yeah, so this is based on both input from the unions, which were the Portland Police Association, PPA, and the Portland Police Command Officers Association, PPCOA. So both those unions are disciplined or will be disciplined by this oversight system and had an interest in this. So and then we also received input from the Department of Justice and incorporated changes and recommendations from them as well. So, in some places, you're going to see where we added language, and we received a letter from some former members of the Police Accountability Commission saying, "Why are you saying the same thing twice?" Partly that was just a request to reiterate some general requirements in certain areas where it's more likely to come up. So it's just to add real clarity of, oh, this is where this situation might come up. Just a reminder that you have this obligation or you have this responsibility or whatever it may be. So one example of a specific requirement we added in was warning employees to truthfully and completely answer all questions or be subject to discipline, including termination. That is a standard warning we give to anybody when there's an investigatory interview. And this was a request that we include that in there, and that was something we added in. The other thing we added in was that the board, the Community-Based Police Accountability Board, would act fairly, reasonably, and objectively. This is required by the Just Cause standard anyways, and is something that that exists already in code. So we just specified it more clearly in the section that relates to it.
And can you just say a little bit about the Just Cause standard, just for anyone who's kind of new to the conversation, where that comes from and what that means in relation to this particularly?
Yeah, so Just Cause is something that exists for unions, and at the city, there's also a similar standard for any non-represented employee who's in our classified service. They have civil service protections, in other words, and basically it requires that you have a fair investigation, that you're impartial in your investigation, that you're consistent in how you approach it, meaning I'm not going to treat Stephanie different than you may, than CMOB. I'm going to investigate and treat people the same way and fairly throughout that process. That folks have notice of what the rules are so that they can bring their behavior into compliance with those rules. And then that our discipline is fair and impartial in the application of it. We do have, just so folks know, we do have the corrective action guide, which really helps us with that because that lays out what we've agreed to and how discipline for different types of conduct is going to be handled.
And I think just to maybe underscore a little bit of that, I just want to make sure folks who might be new to the conversation understand that these cases are employment law cases. They're governed by employment law. So they're different from a criminal investigation, different from like a civil lawsuit. They are kind of under this larger umbrella of employment law that governs how employees and employers can impose discipline on their employees. So a lot of that is very relevant to how this code has to be written and what needs to be followed there.
Yeah, more specifically to that, it's labor law, so unions. So this is something that's applied for unions. Slightly different standard for police because there was a change in the law. But just to generally understand Just Cause. Another change that we made was expanding the annual audit review. We made some changes to that so that when the audit occurs, it'll cover more information in it. That was great feedback. Here's another acronym. We allow for the deputy city administrators to make exceptions for members of the board to vote on administrative investigations, even when training is not completed yet. So we wanted to, even if a board member had not done all the training required, because there's a lot of training we want folks to go through if they're gonna be on the board and making such serious decisions. And at the same time, if there's something they can't get done quickly and there's a good reason for it, we wanted to allow an exception for that person to be able to sit on an administrative investigation.
And just as an example, if somebody wanted to do a community academy, but there's not one available before that, but they've done all the other things, then that would be a situation where the deputy city administrator could consider whether they'd had sufficient training to go ahead and begin working on those cases. We also added a training on this for board members regarding the use of video footage and specifically body cam footage. And the current research around that technology. This is a training that the internal affairs investigators at PPB have to go through. It's a training that current independent police review investigators also have to go through. And so we thought it would be important that we, have the board doing the same training and receiving the same information so that they can evaluate that with all of the same, background information and education that the other components of the system do.
And this, I think this was especially so because we are just starting out with our body cameras, as
Yeah.
many folks know. So very exciting, but also a whole new technology for us. So something we want folks to really understand. What are you looking for? How do you use it as an investigative tool?
All right. Yeah, go ahead, Heidi.
Another change that we made to just make it really specific, I think Stephanie, I understood that this would happen in the other council staff, but it was a good point to make it really clear, and I think it's helpful to say, if there is one allegation that falls under the jurisdiction of the oversight system, and then there's other allegations that would normally be done by internal affairs at PPB, the oversight system will do all the allegations. So all allegations in one complaint stay with the oversight system. So it's not like, oh, there's 5 that internal affairs would normally do and only 1 that the oversight system would do, and therefore it all should go. Majority doesn't rule here. It all goes to, once the oversight system has jurisdiction on one allegation in a complaint, it takes all of the allegations within that one. We have, I don't even remember. I think this was already in there. I'm not sure. Restricting board membership from current and former law enforcement employees and immediate family members of current. I'm sorry, there are a few things left in here. I apologize. That's my fault. Trying to put this together for tonight, and those were already in the charter language. So I'm going to ignore those for a minute because they already exist and they're no change.
Okay.
So apologies for that.
And again, as we mentioned, some of the changes that were made were really just to try to make this a little easier to read, a little easier to understand, to add clarity, and just to move things so that they made a little more sense topically. We also specifically called out that allegations of excessive force would not be eligible for an alternative dispute resolution. They would need to be investigated. So those could not result in no case or no investigation.
And that's so even if everybody agrees. So even if the complainant wanted to, it doesn't matter. Those go through the investigating process.
So we also in the intervening months have had to do some back of the house work at the city as we have begun our transition to the new form of government, and understanding that we are now, I know, certainly city council and staff are very eager to move forward and get this board stood up. So one of the things you may have seen come to your council was an amendment to our Title III, which really just establishes this as a bureau or a program within the city. Oh. Oh. Let's see. What we do?
Oh, we let Aaron go to.
Let our.
Oh, wait, there it is. Oh. There we go. Now it's at you.
That's as far as I Okay.
Look at that.
Do you want it pointing towards us so they can see us?
I think it is pointing towards us.
Oh, I can't see.
It's just a little dark. from
It's
this
just
angle, but
dark.
I think that's right. Thank you. Good catch.
I see.
All right, so the changes that we made to Title III established the oversight board, the oversight system, so the office and the board as a city bureau. It established an initial budget, but they are fully authorized the full budget as required by charter. And to make sure that the board has a little bit of wiggle room to start off with, we went ahead and created the director position, and we created 6 staff positions just so that they had immediate position authority to get hands on deck. They get to decide what their staff looks like. They get to decide what positions they are. We just wanted to give them some immediate things so they didn't have to go through those hoops to just get some hands on deck. So that is done. Council adopted that. Anything else to add about that, Heidi?
It was really housekeeping, but just to make sure that the framework was set up for us to then adopt this code. And actually, we did it just before the fiscal years. Our city's fiscal year, as many of you know, is July 1 to June 30. So we were just trying to do it before July 1 so that the budget office could say, okay, here's the funding, these are the positions that are created at this point. And then, as Stephanie said, this will really go to the board to make the determinations. But at least they'll have some staff to help advertise for the board and solicit applications for it and things of that.
Back here. That's.
Since I'll wave.
Think that other view that back in my head. Probably.
Zero out.
No, but watch the Q and A. Dan's doing a great job of letting us know what the Zoom experience is, so we can.
Dan,
Let's see.
you let us type in if that's better or not.
Sorry, it's just really hard to see on the screen here.
See or
No,
hear
it
or see
doesn't
the
look
room.
better.
Dan, can you hear us? I didn't realize Dan had.
Okay.
Oh, they can hear us. Okay, thanks, Noah.
All right. Whoops. So next steps. Heidi, do you want to kind of walk
Yeah.
through? Yeah.
So we have a court dates held for us on August 29th of 2024. So next month, toward the end of the month, the court has held that date at this time. And that would be for the court to hear changes on Section 8 of the settlement agreement. So in order to adopt and stand up the new oversight system, we have to make changes to the settlement agreement. And this was anticipated when we made amendments in 2022. So, so if it's, assuming we go forward on August 29th, and if the court adopts the changes to the settlement agreement, then that starts a 21-day period for council to adopt final code amendments, which are the ones that we're talking about here tonight. From the point at which council adopts the amendments to code, we have 1 year to stand up the board and have them start taking cases. As some of you may know, the plan has been all along that the oversight system would start taking cases. As they start taking cases, the independent police review will stop taking new cases, but will continue finishing the ones they have. So as time goes, we will see this shift so that the cases are ultimately in the oversight system, but independent police review and citizen review committee will stay on to finish up those cases that were already started with them.
Yeah, and I think just to go a little beyond what we said here, as soon as the fairness hearing is completed, and assuming that if that, you know, authorizes it to I guess, I don't know what the right word is. If the court finds that this code is fair and adequate, and then it moves forward so that council can vote to adopt the code language. If council votes to do that, then I think from there, we will be moving full steam ahead to start our recruitment for board members, to get that nominating committee stood up, and to really work quickly so that we can, really have things moving forward with this new program. I will also say, I think if it's helpful, because I know I've got time here for Q&A, but Heidi mentioned this before, we received a letter from the former members of the Police Accountability Commission who sent over some great feedback for this current round, as well as some questions. So we were hoping just to kind of walk through those, their letter, and answer those questions. And then we're also happy to take questions from, other questions and do whatever we can to answer those. What's the best way? I'm trying to think what's the best way to do this. I could probably share my screen with
Oh,
the
that sounds
letter.
That seems like a good idea, because I think it'd be helpful for folks to be able to see.
Let's
I do want
that.
to take a moment to thank the Police Accountability Committee for the thank yous that the letter started with some thank yous for some changes, and appreciated that. It's we do work hard and listen to folks and incorporate where we feel we best can, and appreciate that you saw that and saw that we were listening, even if we don't do everything, but that we were listening. So I did want to thank you for your thank you.
Yeah, thank you, because, again, as we've said, we know it's a tremendous amount of work that went into the recommendations, also the feedback that's been provided, and, we really do appreciate all of that, and are doing our level best to incorporate it in every way we can. So yeah, I think just walking through here, we can see the thank yous with regard to complaint navigators, which we spoke about, and expanding the jurisdiction to investigate all cases if they have an allegation that falls within the board's jurisdiction. Let's see.
We expanded, the other one was the expansion of the jurisdiction
Yep.
and putting him under the deputy city administrator for city operations.
Right. All right. So new issues that have been raised by the former PC members. So this initial paragraph, I know there was questions and concerns about having specific language regarding or repeating specific language from a prior section. Again, this in this case, that was done again for clarity, so that there doesn't have to be a ton of cross-referencing throughout, when we can make it just clear by restating that. And we hear the feedback on the Boulder code changes, and we'll consider that. Let's see. With regard to their second concern, which is noting that the code allows when an officer's name has been publicly released by the city, that an audit can list the name of the officer, and noting that that is slightly different for the board's annual report. We're going to consider that and take that back to our partners to talk about that and see if we can, if there's a change that we can make there so that those match, but we have to talk with them about it first. So thanks for bringing that to our attention also.
And to be clear, they would be, the names would be publicly released in connection to whatever the discipline was or the investigation. So if for any reason the name's already been publicly released in connection to that, so that people already have the connection to the discipline, then we had it that we would release it in one place but not in another, and it was good feedback. We appreciated that. I see there's a question about when you can start asking questions, Charlie, and we're just we wanted to respond because folks took the time from the former Police Accountability Commission to send us this letter. We just want to take a little bit of time to go through those questions. If anybody has a burning question that, and they have to leave early, please raise your hand or post it in the chat. I'm trying to track the chat or the Q&A, excuse me. as we go along, and we'll do that.
Yeah, and I don't mind. I think we can kind of bounce around here. We just wanted to make sure that the PAC's letter got responses since they had, taken that time and tried to get that to us in advance. I will just jump over, though. I can answer details on the application or confirmation process for the board. So our timeline, we do not have a clear timeline on that yet. That's going to be after the DOJ hearing, and only once council adopts the code language, and then the nominating committee that's outlined in the code would put forward some kind of a recruitment. City staff will help, advance that recruitment and get candidates together for the nominating committee to review and make recommendations about. And then ultimately city council will appoint the members the board members. The board there's a question here that says, asking whether the board will have funding to create flyers and purchase advertisements throughout the city when they are established. They do have an existing budget, so they can certainly use it for recruitment purposes. Debbie's asking, when we talk about partners, who do we mean? And I think what we mean is our labor partners, so our labor unions that are impacted.
And then also Department of Justice.
And Department of Justice.
So both of them. But when Stephanie said on that suggestion that was made about if the name's already been released, we had it in one area that we would publicly include it in a report. Why wasn't it in another report that was done? That's the one that we'll take back to both our labor partners and the Department of Justice and see if we can get consensus on that to do that.
All right, back to PAC's letter. We have, I'm looking here, I'll just try and make that clear so I know what we're talking about. Looking at this question, there was, again, concerns regarding the number of members as well as the number of members required to establish a majority for voting on full panel cases. And I think that's feedback that, we've heard. We consider that. And all we are trying to establish here is just a simple majority of the membership with that. But again, we're happy to take another look on that. I'll be transparent. I don't envision the number of members to change at this point in this code. All right. I think we spoke to this question regarding training related to video and body cam earlier. So again, this is we've added that language in to ensure that the members of the board and the office are receiving the same training on this, technology, which is not new, but is new to us in Portland, so that they have exactly the same access to information that internal affairs investigators have and that currently IPR investigators have. We'll note here, the red line that was originally posted was comparing one version, I think, back. So the red lines were less significant than those posted originally by the city. The link that's there now is correct. There's a lot less red lines, so apologies for that. It reflected more changes than were actually made. So again, apologies for that. That was a word processing error. Okay, with regard to this concern, asking why the code language is limiting recordings of interviews to audio instead of video, there's a couple of reasons for that. Heidi, if you would.
Yeah, one of the main reasons is this is a longstanding practice, and changing longstanding practices can be challenging in labor, whether it's police union or any other union. Longstanding past practices tend to be challenging to change. So given all the changes we were making, this didn't seem like one that was one that we needed to do at this time. It doesn't mean we can't consider it later, but at this time it seemed a reasonable change to include in there. And then the other thing is just sort of a practical concern, which is that video takes up, more storage than does audio recordings. So that's the lesser reason, but still an influence for us.
And I'll just say that's kind of a front of mind thing for city folks because of the body cam project and the adjustment that's being made there. So I would reiterate what Heidi said, which is this is something that I don't think it would be a long-standing or a permanent practice. I can see this changing in the future. Okay. Next one here.
I would just note that there are several places in the code that makes it clear that the oversight system investigates deadly force cases. So we didn't feel the need to say that because the section that's referenced about when there's a deadly force administrative investigation, they will not interfere with the criminal investigation. You're kind of, it's saying right there, there's going to be an administrative investigation that occurs. That's one of the areas that's under their jurisdiction and that will happen. So the administrative investigation into a deadly force incident absolutely is under the jurisdiction of the oversight system. That's in charter, it's in code. And so we felt that was very clear. It's said in many places that's her job. And just one thing that people may not be aware of, but when there's a criminal investigation going on, we are very careful to separate that from the administrative investigation. And this is because we can undermine the criminal case if we gain information in the administrative investigation. So we're investigating a police officer or say an officer involved shooting and determining whether they followed policy, whether they used excessive force, etc. And in that process, we are requiring them to answer our questions fully and truthfully. And just like anybody, when you're being investigated criminally, officers and everybody have a Fifth Amendment right to remain silent. It's odd when you work for a government entity and you have a criminal investigation going on by that government entity, and at the same time you have an employer investigation, the government entity acting as an employer. And in that instance, we're compelling them to answer our questions. So we have to have a clear wall between those. So there cannot be any interference by the criminal investigators into the administrative investigation, because that can completely undermine the criminal investigation. Because you can get information you shouldn't get because you violated their Fifth Amendment right on the criminal end of things, but not on the administrative end. So hopefully that helps explain it. And that's why we felt the language was clear enough and that the criminal investigators understand they cannot access the administrative investigation.
I'm gonna group these two paragraphs together because they are somewhat related. And it's sort of what you spoke to, Heidi. But the first question is whether it makes sense for the office, the new board's office, to share its protected files with the chief of police and the city attorney. Can you talk a little bit about the interaction between those?
Yeah, so just so folks understand even now, so as the chief of police, the chief's job is they make a final decision about discipline. So whenever there's an administrative investigation, whether it's deadly force, excessive force, satisfactory performance, you name it, anything that there's an allegation that an officer violated a policy, the chief is the one who makes that final decision. So that administrative case always goes to the chief of police, and they always need to separate out from the criminal case. Again, the chief of police will be the first person to ensure that we're not interfering with the criminal case, since that's their job, is to ensure that when you have violations of criminal law that they're able to enforce those. And so they already do that. That's nothing new. Our office similarly provides advice on labor and employment. That is one of the primary things that I do, along with the Department of Justice settlement agreement. And, and, and out in our office, we have, the labor and employment group. There's several of us attorneys advising all around the city. Our work is, we have a separate, not server, but an area in the server that's locked down to other people within the office. So none of our litigating attorneys can access our information. None of the litigation paralegals can access it, et cetera. It is all walled off from the litigation group. And so that way we can ensure that in an investigation to an employee disciplinary matter, we're able to give advice and we're not interacting and sharing information with the other attorneys who are handling either the day in, day out operational advice. So I don't give PPB advice on their daily, day in, day out operations. Because I'm the one advising on whether they should be how to discipline, when to discipline, and defending the city in upholding that discipline if there's a challenge to it in arbitration. So I keep very far away from the general advice attorneys. We talk about legal issues to the extent I want to understand something that's a search and seizure law that they understand maybe better than me, but we really keep separate as far as the information that we have. So that's why we have the chief being able to get information about investigations as well as my office.
Similarly for the training division is part of the review process for
Officer involved.
yeah, officer involved shootings or in custody of deaths. So these are all pieces that are required to engage on these in different levels in different phases during the case. So that's the reflection there, right?
Yeah, and that's current practice. So currently there's a review and we have somebody here who's been through this process before. We have a review, not only is a review by internal affairs to see if they complied with policy, which now going forward, once the be doing that assessment of whether the officer's conduct complied with policy. But for officer involved shootings and in custody death cases, the training division also does their own review of the incident to see, did the officer's conduct, was that compliant with training, or did they do something different than what training says? And all that information comes back currently to the police review board. Going forward, it will all go back to the oversight system so that they can make a full decision about an officer involved shooting or an in custody death.
Okay, next note from former PUC members is regarding, let's see here. Let's see, the way
Stephanie?
this, I'm sorry. Go
I
ahead.
just said, Dan had wrote regarding Charlie's question, I think it may be helpful if you check in with the PAC, Police Accountability Commission, to see if your answers are reflective of the question. Some of us are prepared to be subject matter experts depending on the question. Dan, I'm sorry, you posted that about 5 minutes ago. But if you have feedback and want us to pause, then please feel free to. Oh, Charlie, thank you. The changes that have been made are particularly problematic around the notion of bias, which overlooks all humans have bias and conflicts with the city core values of equity and anti-racism. Oh, I'm sorry, and it conflicts with the city core values of equity and anti-racism, as people representing the city are required to, quote, acknowledge Oregon's history of exclusion and be dedicated to rebuilding trust through reconciliation and restorative justice, as well as prioritize addressing issues concerning anti-Blackness. Both require having some negative views about the police insofar as they have contributed to the anti-Blackness, exclusion, and breaking of trust. This needs to be removed because this is why 26-217 came about. That's the ballot measure that changed the charter language, and why the police accountability, and why the community-based police accountability, or community board for police accountability, excuse me. I think that I'll let Stephanie chime in on this as well. I think that when we are including bias, it doesn't mean that people haven't had experiences, nor does it ignore the systems that we live within and the institutions that have that we all live within that impact some groups of people who have been historically underrepresented, more so than others potentially. And so, so I think when we're talking about bias, it's biased so that you can't make a decision. Your bias is impacting you so much that you really can't make a fair decision anymore. So I think that that the current independent police review language has that. The settlement agreement with the Department of Justice has reference to not having bias interfere with decision making. And so we felt like that was a good thing to include as well. But do understand that we all abide by the city's goals and commitment to anti-racism, to equity, to collaboration. And so, so I think that that's not something that we are ignoring in this. That's a good question, Charlie. Who is qualified to make that? You know, I guess it's the same thing, you know, when we have judges that, in any instance, when you go into a courtroom with a judge or any decision maker, you want them to the extent they can, understanding we all have lived experiences that have impacted how we view things and how we come to the world. But to try to set those in the background, informing your decision, but without influencing your decision so that you're no longer fairly doing it. And I think that's all we're asking of folks is, can you know, when folks go to be a juror, I remember this question, I used to be a public defender. I remember this question all the time of, can you fairly and impartially decide the facts of this case and do it without your bias influencing you? And that's all we're asking folks to do. Well, that's all, you're right. We're telling them in order to do this, you need to be fair. Yeah, CMOB was saying, we're not really asking, and you're right. We're saying you need to make decisions fairly, impartially, and without bias. That is true. Thank you. Good correction.
Yeah, go ahead, Adelia.
Yeah, I'm just wondering how, when, if that bias, like how you see that. Let me start with, how or when does bias impact that? How can it be?
Yeah, I think it's a great question. I think the obligation of the city is to do our best, our level best to try to identify folks who believe at least that they can set their biases apart. We don't want people to abandon their life experience, but we do need to try to do what we can to ensure that people are able to listen to all of the evidence that they get to be presented with, that they're able to, you know, assess that and make a judgment without being completely swayed by their bias or refusing to consider certain kinds of evidence as a result of a bias. That's really, that's hard to do. It's hard to guarantee, right?
Say that it's.
Can I-
Guys, biases. What is the metric of bias? What's the definition?
So just so folks online know, the first question was, how do you know how or when bias impacts the decision? And then the second comment is similarly, how do you assess that? And I think that how do you
What is the
define
word-
bias?
definition of bias? How do you define bias?
I think if you have strong feelings for or against police that are so strong that you aren't able to listen to everything and make an objective decision about things, that's where your bias is influencing. How do we know when somebody's doing that? It's not, as Stephanie said, it's not an easy thing to determine. But I will tell you that if there is a if there's a discipline decision by board members where there's evidence that they have a biased, well, if there's a bias for police, you all, I imagine, are gonna tell us. And if there's a bias against police, then I know the union's gonna bring it up and it can undermine my ability to defend
I
it.
mean,
It's-
that's the thing, right? That I think actually has a lot more answer. To assume that we would only call one side out. And being a former member of the
Good point.
Police Accountability Commission, that does allow us to see exactly what light we have been casting, completely as a whole. I've never personally, I've never demonstrated this bias, but it is expected that I would fall only pro-police bias and not anti-police bias.
That's
Right.
fair. That's
Um,
fair.
And so therein lies the problem. With a lot of this process, and you mentioned a lot of our work, and liquefying it, diluting it basically, and then having this moral appeal to, to language that definitely, kind of takes away, weight from the work that was initially started. You know, I'm not gonna cry about it, 96 pages, 27 pages, significant, but
Oh,
Thank you.
that is.
You have
gone.
to- That's done, okay.
That is gone. They're here. We're forced to be here. We're still hanging on. you know. So, thank you. Not to belabor, but I guess the main point would be, you're not giving us an actual place where we can resource the definition. We're shooting from the hip, and part of shooting from the hip was telling that as former police accountability commissioners, we only see one side. So you actually answered it right there. That's the unfortunate thing. Because a person like myself, I can ask you personally, and I'll probably get a very personal answer, that won't spell the truth as to how you will actually do if I do have an interest in the sport. I can certainly guarantee that the impression is that I have anti-police bias. And yeah, that's unfortunate.
Fair call out, and Seema, thank you for saying that, and I appreciate that. And I will be more thoughtful going forward and not make assumptions, because that's exactly what we're talking about, right? So it's an assumption I'm making. I've heard a lot of concerns from you about police and whether they're being fair, and I think. And then I'm making an assumption from that. And so fair call out, and you, I agree with you 100% on that. I am too. I want to see police accountability as well. But thank you. It's a good point, and I'll be more thoughtful going forward. I appreciate you calling me out on that and pointing it out to me.
Sorry.
I was just. Should we get to my-
Yeah.
Yep.
Thank you so much.
Thanks, you may.
Hi, oh, hello.
I
they
think
can
it
hear.
goes to the Zoom, so.
Okay. Oh, okay. Hi, my name's Odelia. And I was just more, I don't think I phrased my question correctly, but I'm wondering how you would even like screen for bias in the application process and how you kind of envision that.
Well, I think, I mean, we do this to a degree for our advisory bodies now, right? If we're looking for people who don't have a conflict of interest with the city, that's one level where we have, maybe have to do a conflict check with the city attorney's office, or, reviewing publicly available information about an applicant, or, and interviews also, I think is another thing. But we also design and would, for this case, design an application that's intended to try to elicit information, understanding that's not a perfect process, but I do imagine that the nominating committee will be looking to interview all, the applicants and to speak with them and try to learn as much as you can. There's no perfect system for that. I think CMOP's done a great job pointing out there are lots of assumptions about someone's bias that can be made if they're only looking at one aspect, or, focused on one specific thing. So I think that's a really important goal for the recruitment process, to try to find that correct balance and make sure that there is objectivity in the membership. And frankly, I think the members of the board are going to be, they're going to be working really hard, I think, to maintain the credibility of their work, which means calling out bias on any side, on any issue. And I think that, there's going to be a lot of effort done by the folks that are appointed, and I think frankly by the people who work for them in the office, to be vigilant for things like that. The other thing is that everybody, I think in these situations, that maintaining the integrity of these administrative investigations is incredibly important, because what needs to happen for an oversight system to be successful, their discipline needs to be upheld, that needs to be imposed, right? And so all of that, as the PAC well knows, goes directly to the credibility of that system, making sure that there is no argument for bias in that, and making sure that there's everything, the city, if it needs to defend it, is in that position to say, nope, here are all the steps that were taken to make sure that the folks who are doing this work, were objective and fair. And that's why this investigation was objective and fair and should stand.
And I would add to that too. I think that always the question of whether somebody's being fair, can you be fair? Can you be impartial? And can you be unbiased? I think all of those are hard to tell from an application. And that some of it is gonna, we'll find more when they're on the board itself, and that requirement retains throughout. What does it mean to be fair? What does it mean to be biased? What does it mean to be impartial? I think all those things are seeking to have decision makers be open-minded, listen to everything, and then try to come to a decision that really applies the rules that exist. So whatever policies and rules we require of our employees, that can you look objectively at the facts and determine what those facts are, and then can you fairly and objectively apply the rules? I do think a lot of that, it's hard to screen for it. I think you make a valid point. I would say it applies with the other adjectives we've required of folks as well, along with bias. So I don't think it'll be easy to tell from the outside, and unless somebody really has a strong bias, or really is unfair and really is not impartial. I don't know how else you would really see that.
You've been patient.
Well, I think you answered most of it. I was just gonna say, to what degree, on a technical level, to what degree are we putting this onus on the nominating committee to parse bias, versus how often are you envisioning this more as something that's gonna come up if the decision gets grieved?
I don't know. I mean, from my perspective, I think all those, like I said, I think bias, and whether you can be fair and whether you can be impartial and can you come in unbiased, it's hard to tell from an application. And sometimes the proof is really in the pudding, if you will, and how do people actually act on a board and hear information, and do you hear them going completely 180 degrees away from facts that are pretty clear. That might reflect something, and maybe reflect that they're not impartial, or they're not fair, or they're biased, and it may be hard to tell which one of those is, or if it's all three. But I think that's it's a good point. We have a lot in the chat, Grant.
I've been working on that.
Oh, good. Okay. Do we have other
I think good deal,
questions?
yeah.
Okay, yeah.
Oh, please.
Kind of just correct me if I'm wrong, but someone from the PPA is on the selection committee, right? But I feel like you just sort of kind of alluded to the fact that they had pro-police bias. So it's hard for me to understand when and where that bias is viewed as just a part of the job, or something that can't be a part of this process and system.
One clarification, they're not on the board.
No,
Yeah,
they're on the selection process.
They're in the selection.
Yeah.
I can hear. And I just want to make that clear, just so that anyone who's listening heard that. Thank you, Steve.
Oops. But before. I think that when we're talking about the nominating committee, we did not say that the nominating committee needed to be unbiased and fair and impartial. I hope they are. But we have 9 members most of the time. The first one's gonna be 10 because each council member, of which we currently have 5, will appoint 1 member to the nominating committee. And then we have the 2 CRC members. So there are going to be 7 community members. And then there will be 1 member from the Portland Police Association, 1 member from Portland Police Command Officers Association, and the chief or currently his designee will appoint the other person. So for the committee. And then going forward, the each district of the 4 districts after January 1 of 2025, so for this election period, actually, each district will appoint 1 member to that nominating committee. At the end of the day, though, council decides whether to appoint somebody to the board, not the nominating committee.
But I guess if like they are playing a role in it, how come they don't have to?
But the question was if the police association is playing a role in it, then how come they don't have to be unbiased? All right, I'm gonna repeat back what CMOP said to me earlier which is that you're making an assumption that the police association is gonna be biased for police.
Send this back to the voters, that was a clear indication that the PPA as well as the union itself are clearly against this entire process. They have
But-
invested,
Also, I think like.
that is a clear bias.
We gotta make sure folks online can hear too, so.
I think that that for the nominating committee, we're gonna hope that everybody who gets appointed, whether by council folks or by the police association or by the chief of police, whoever, we're gonna hope that they are unbiased and that they come and they're fair and impartial in looking over these applications and reviewing who to nominate for the board. And keep in mind, there are 7 community members on this first nominating committee and 3 people from police. So if, you know, I don't know the members that the citizen review
There will be,
committee.
this has not been done yet.
Yeah, that I don't know the members that the citizen review committee will appoint. And I don't know how Portland Police Association or Portland Police Command Officers Association will view those 2 citizen review committee members. They may assume, and I appreciate that point, I think it's really a good one to make. They may make an assumption that those folks are biased against police. I don't think that's necessarily true, but, and so, you know, and yet we're trusting all those folks to work together, 10 people and put names forward. But at the end of the day, it's gonna be, you know, that you've got 7 community members and 3 who come from a police background.
And let me also say, the nominations are done by a majority vote. It's not that each member gets to put up an appointee. It's done by a majority vote. Also, council does not have to accept the recommendation. So if there's concern, there's also an opportunity for community to weigh in at council on any appointments, as there are for any of our advisory boards. And that happens from time to time. So there's, you know, I hear you. I recognize the point that you're making. I think I understand. I get the concern. I think we're also talking about trying to establish, again, boards that have credibility, that we can, you know, uphold the discipline that this board decides, that we can defend it, that we can make sure that the work that they are doing is also, you know, it has been through enough of a rigorous review, and we can maintain that objectivity so that we get to defend it, you know, anytime it's challenged. But that's,
And just to be
and
really
that's part of it, right?
one sec, let me just be really clarification, which is that the initial nominating committee is made up of 10 folks. And that's because we have 5 council members right now. But going forward, it will be 9 people on the nominating committee because each council district will appoint a member. So there'll be only 4 instead of 5. So to be clear, going forward, the nominating committee after this initial appointment will have 6 community members and then 3 police.
Yeah, and just to clarify my question earlier, I think, like to your point about the ballot, I think that's really important to think about here, but even like disregarding ballot and law and things like that. I think to your point earlier, Heidi, and like not to call you out, but as you were talking about assumptions of like PAC members, you also said that PPA will have the pro-police bias, and so that's kind of where my question came from, was like that I think that's like perhaps a valid assumption to have sometimes, is they literally represent police, right? And like bargaining power and things like that, but also, yeah, it was kind of coming from like what you stated earlier. But I can stop talking about this now.
You made a lot of good points.
I
Appreciate it.
will say, I know, I see in the Q&A that we've got former PAC member, Faith, who would like to join this, so I'm gonna just invite her to raise her hand so I can unmute her. All right, there we go. I think Faith, you should be able to.
Hi, can you hear me?
You might need to speak up a little bit, but I think we can hear you.
Hi, thanks so much. Can you hear me now better?
Yes.
Yes.
Amazing. Thank you so much. I've been like chomping at the bit to talk about this nominating committee. My name's Faith. I'm a former member of the PAC. And I want to reiterate the thanks that we offered in our letter of the recommendations and the changes that you have made. And this is an area that I think the former members of the Police Accountability Commission feel strongly about, where there could be potential change. While I don't want to make any compromises, and our initial recommendations on a nominating committee did not include any police representation, I understand that you're negotiating with the PPA's bargaining unit, and I would ask that you would consider lessening the number of police representatives on this nominating committee. And another detail that hasn't been covered is it looks like there will be, I don't know if it's the same nominating committee, but that will be recommending who the director of the office would be. And in our initial recommendations, there definitely was not any police representatives in the selection process of the director. And so I would just ask very directly that between now and August 29th, when you have the meeting, that you would consider a way to lessen the number of police representatives on this nominating committee. I think that we share a hopeful outcome of having work that we can stand by. And I think that this is a detail that I don't imagine community will be able to overlook. So I'd ask you to consider bringing this back to your partners at the bargaining unit for PPA and PPCOA. Thank you.
Thanks, Faith.
Thank you, Faith. Anyone else in the room? Okay, I'm gonna go to the Q&A here, looking for questions. Okay.
So will the voting record of all oversight members be public? Well, yes and no. Yes,
Wait,
in
can you
that.
restate the
Okay,
question?
so the question is, in the chat is, will the voting record of all oversight members be public? Actual votes under public meetings laws have to occur in public session. All the background discussion on discipline happens under public records, public meetings law happens in executive session under those laws, unless the employee opts to have it be public in public session. And so, so the actual voting record will be public in that the 3 board members who are hearing a disciplinary matter will consider everything in executive session, and then they'll come out and just vote whether they vote sustained or not sustained. And in public, but it won't be the employee's name, and the actual allegations will remain anonymized.
And the person who asked this question also has their hand raised, so I'm gonna allow them to let us know if we've answered their question. TJ?
Can you hear me?
Yes.
This bias issue is exactly why I tuned into what I thought was going to be a public input kind of meeting. And the bias goes both ways. The first CRC that I served on, we had one member who wouldn't vote to sustain a complaint against a police officer if that officer had smacked a child in the face in front of 14,000 people. He just would not ever take a position against any police officer. So bias runs both ways. And there wasn't any way we could get rid of that person. And so the idea that this is only one directional is not true. But I've experienced in both ways. And so we have this rhetoric that says fair, reasonable, unbiased decisions. And I don't see, and that those are wonderful thoughts, but I don't see any means of actually verifying that that is what's happening. And the reason I asked the voting record question is because in that case with that CRC that I served on, it would have been very obvious that that guy was biased. And that's why I asked that question.
I think that's a good point to make, and I think it's a helpful point to make. And important that if we see somebody ignoring the evidence, like you're saying, there's numerous witnesses who view something happening, and several people are saying the exact same thing over and over and over and over about somebody, and then you've got one person who, in case after case, is just coming to a totally opposite conclusion. You know, now we're gonna have video evidence as well, which is helpful. That will very likely be an indicator of bias that we need to look at. And in that instance, then there can be a decision to remove that board member immediately if the deputy city administrator, we gave them that authority. I think in the moment I was thinking about because we've had it happen before where somebody does a violation of our anti-discrimination, harassment, or retaliation rule. But this is a good example too, where if we have evidence where somebody's repeatedly demonstrating a bias for police or against, either way, but for police in the instance you're giving, that's not somebody we want on the board either, because they also are not able to be fair and impartial and unbiased in their decision making. And then in that case, you know, we can remove that person and then bring that removal to council to ultimately take them off the board.
Okay, I'm gonna move to another question in the chat from Dr. Silver. And she's asking, is there a process for times there's disagreement between the board and the chief regarding discipline?
The process is simply that for investigations done by the oversight system, the chief has the opportunity to provide feedback and their perspective on the investigation and recommendations. And then the board gets to consider that, but the decision is up to the board. The chief can't force them to change their mind and has the ultimate decision-making authority. The chief can express their opinion to the board members who are hearing the case, but the ultimate authority is with the board throughout the process.
Okay, I see another question here from Debbie Iona, and I think this is going back to the question of public voting. And she writes, in other words, we will know how they voted, but we will not know what they are voting on. Is that right?
That's right.
Okay. I'm gonna go back to the document from the letter from the PAC. And let's see, I think that is right where we left off regarding the case summaries and the public public presentations and summaries on those. So I think we have addressed that. Next, concern that was raised, and feedback that we received was requesting, well, I guess noting that the PAC's position is that individual compensation for board members shouldn't be up to city council. And their belief that council should set guidelines for the staff to use. And as an example, they say council should not have to vote every time the OCPA reimburses a member for expenses. And I think we wanted to clarify that was not the intent of that paragraph, to have members from the staff go to council every time they do a reimbursement or anything like that. I think the point being that reimbursements have to be consistent with various city policies, various legal frameworks, and so that would be established by city council in compliance with the law there. So I think we can take that feedback and maybe see if we can make that a little bit clearer, that we're not saying city council has to review every request for reimbursement. Okay. Next, I see the letter is talking about the term majority consensus. And the confusion that creates, which I think is absolutely valid. I think one thing we can look at doing is changing the word from consensus to agreement, because I think that's what the intent was, not to confuse a majority with, consensus model decision making, but that it would just be majority agreement. So that's something we're absolutely going to consider, and I think we can wordsmith to make that clearer. Okay, ongoing concerns.
Can I
Uh,
respond to a comment? in
Yeah,
the
yeah,
chat?
please.
Charlie, you had mentioned that, you're concerned, and this has been a concern raised a few times. This is not the first time, you're right, that this has been raised about the ride along and concern that the harm that can cause to some people, and a barrier that it can create, and triggering of trauma for people who maybe have had really negative experiences with police. And yet are fair and able to be unbiased, and somebody we would like to be on our board. One thing that you had suggested was that if we're not going to get rid of the ride along, that why don't we have some balance of that, and have board members also talk to people who have been experienced violence and oppression from police. And I was looking through that because I thought we had that, as far as just ensuring that the board members, as part of their training, receive instruction about Portland Police Bureau's history, procedures, policy development process, MPPB's training on de-escalation, equity, bias-based policing, and crisis intervention. So my hope would be that would incorporate some of the history that led to the interest in folks and voters approving the oversight system, and which is another thing that training that folks on the board go through, is becoming familiar with the history of the charter language as well. So I think it's a good idea. If there's something more specific that you think we could do, I'd love to hear from you on that too. So. And I copied your comment down and put it into my notes.
And it looks like Simon has something.
Hi,
first.
yeah, I'm gonna stick to a particular theme here, but decisions when it comes to even ride-alongs, like can you point us to specific resource that you guys are using to define the benefit of a ride-along? Not just hearing your opinion on what it may be, but like same thing what I was talking about bias earlier. Where are we pulling the definition and how to define this? If it's not being pulled, can you guys create something that can reference exactly what pro-police and anti-police bias is, but also in this same case, like when you guys are asking these people to go on ride-alongs in order to become a member of this board, what is it that you're looking to have these people gain, and what is purpose? What is the benefit of forcing this right along on potential board members? But not just like have these things be shared based on what you guys have to say right now. If you don't have an answer for it, I'd actually truly appreciate that, because I'd appreciate it that if you guys didn't have the firm answer for it, that we're looking to foment exactly what these definitions are and how are we defining these stances and how are we actually displaying these for people to see, read, and understand. Oh, well, why ride along? No answer. Nothing easily found.
I can say a few words about that. I believe right now CRC members and PRB members are required to do a ride along to participate. So that's been a practice. But I want to say this from my experience as a trial lawyer, as a public defender, as a civilian law enforcement oversight. I did that in Denver for not a prosecutor. No, I was a public defender. No, big
Wrong
difference. No, but and then after that, I worked in the Denver's office of the Independent Monitor, which did specifically oversight of the Denver police and the Denver sheriffs, all of their internal affairs investigations. And I will tell you from my experience, the ability to observe, to directly observe behavior of law enforcement in the field is extremely important in my view, if you're being tasked with assessing it. If you're also being tasked with how that it should be improved. And I think those direct observations are incredibly important to inform how questions are asked and how things are done. I will also say, as somebody who has watched thousands of hours of body worn camera footage, and I'm not exaggerating by that, seeing horrific things. This board is going to see really horrific things in the cases that they are investigating.
And I can appreciate that. Again, just to preface, when I started and I said this, I imagined that you guys would have an opinion, but to be able to say, put it in writing somewhere, the benefits of a ride along for, let's make these things defined and found. Otherwise, they have no place if it's left up to opinion and hopes and values. These things need to be much more concrete, and I don't want us to get lost in the grays over here of what could be what we hope to define as certain things, because then if it's just left up to the grays, then the assumptions are always going to be there. Well, why are people considering this punishing if you can't put it in writing that it's a benefit, right?
That's fair.
So I hope that we approach that. I doubt that it will, but again, we're left over here communicating with city employees that defend the city, therefore defend the city from liability from police, ironically, to hope that we can push police accountability through. And so there's some
I do the
obvious things.
opposite.
Not that.
That's not what I do. My job is to defend decisions that are made to discipline officers and others, but officers, and to hold them accountable for their conduct. So if you look at the Hunziker case, you'll see my brief. We lost. I was very upset about that. I think I made good arguments. I think I should have won. I think that played out later that I should have won. But that's my job is to strenuously defend the actions where we're holding officers accountable, and the discipline that we do.
I appreciate that. Thank you.
Yeah, thank you. So I'm with you 100% on that. I really do think accountability is extremely important to me.
Yeah, I kind of straying away from the body worn cameras, but I think to your point about like the importance of definitions and having everything in writing, I think going back to the bias section, I think it's really, really crucial for that to be expanded on for what that does and doesn't look like. And especially if a member of the board can be like essentially kicked off for their bias. We need to know why and how that happens, like very procedurally, how to determine that and define that. Because then folks could just classify it as like, oh, this person voted 4 times against this yeah, and then it could just become a situation where anyone who does that has bias, and so I think it's really important to do that preemptively.
I think that's a good idea to preemptively define some of these things. I appreciate both your comments about that and providing greater definition around some of these terms. I've written that down. There are a number of things that we're hoping council will send to the board members once they're first created. And many of the things that were in the recommendation for the code from the Police Accountability Commission, we put into another document. We want to send that to the board and ask them to adopt rules of that sort, because the code language is pretty broad and high level. And then and there's a lot of detail that will still need to be filled in, and that's appropriate for administrative rules and policies and things of that sort. So another thing I've just taken a note on, I think that is a great idea. I think it probably would be better in an administrative role to have that definition. You know, similar to, we have definitions of discrimination, harassment, retaliation, things that sort in our rules, in our HR administrative rules, but the board will adopt administrative rules as well. And I think that's a really good idea to have a definition of what is bias, what's fair, what's impartial, how do we know, you know, what are indicators when somebody might be facing removal from the board? Because yeah, you could appropriately vote to sustain a violation 50 times, and you could appropriately vote to not sustain a violation 50 times. And that doesn't mean that you're failing to be fair, impartial, and unbiased in your analysis. So I think it's a good point.
Yeah, appreciate that. I'm not sure I'm seeing in the Q&A, and I'm not sure, Charlie, if you want to raise your hand, if you want to speak, please feel free to do that. I'm happy to, you know, give you a shot to respond. So I don't see, there's a lot of comments in the Q&A, not necessarily a lot of questions, but all is appreciated. All right, well then I'm gonna move forward here. All right, so, you know, I know this has been this is under the category of ongoing concerns from the police accountability members, the former police accountability members. And this particular paragraph, it raises again the concern about not creating an avenue for community members to file an appeal. And I think, you know, this is a really technical issue that has to do with the framework of employment law and the timing of when those can happen. What we have tried to do to answer to that is to ensure that the complainant can see what the results of the investigation are, can have the opportunity to complete an impact statement they get to share with the board any feelings they have, if there's information that wasn't considered properly, if there, the impacts of all of this to them that may or may not actually go to whether there was a violation, that, speaks more to the impacts. That impact statement is the ability for them to provide all that information and ensure that the board that's making the decision has the ability to review all of that information before any decision's made. The tricky part, Heidi can explain this better, but in the framework of employee discipline and the employment and labor laws, that has to be done in a certain order. And so this is the way that it is created here, that is the correct timing in order to ensure they have that feedback. The other thing to remember, again, is that these cases are strictly employee discipline cases. They're only between the city and its employee to determine how the city imposes that discipline when there's been a violation. It's not unlike the criminal justice system, which has, you know, complaining witnesses who are not parties to the case. And so they don't, you know, if there's a trial and somebody is found not guilty, that complaining witness doesn't get to file an appeal of that decision. And it's the similar sort of framework that we have that we're bound by in these cases. And so we really work to try to create this as an opportunity to make sure that there is the opportunity just to share openly any feelings or any impacts or concerns that they have before decisions made.
You did a good job.
Okay. Um, all right, so this question, the code just allows the mayor to decide whether the system will investigate allegations of misconduct against the chief. Do you want to speak to
Oh,
this?
yeah. So, the charter amendments, that established the oversight system occurred in 2020. And then subsequently, Portland voters, we all voted on changing our whole form of government. In that vote, which happened later, there's a specific reference in the new charter language that talks about that the police chief reports to, is hired by the mayor. It's he or she or they are subject to council approval, but the ultimate decision making to end that employment relationship is with the mayor. And so so that is a very specific grant of authority that happened later in time to the original charter language creating the oversight system. And so in looking at those and looking at the way that our charter is read, which is in essence our constitution. So how do you interpret a constitution? The specific controls of general. So where we had a general grant of authority to the oversight system to investigate sworn police officers. Then subsequently, we had a specific grant of authority to the mayor to decide whether to fire or not the chief of police. That made it clearer that that authority just for the chief of police rests in the mayor. The other piece that was influential in that decision was the fact that it was subsequent in time. So the later amendments to the charter creating a new form of government, along with the specificity in that later charter amendment, was what made us say that we couldn't have the board make a disciplinary decision. And that's why we said, well, they could make a recommendation to the mayor. But that's ultimately the mayor's decision. So we put it in there with the strongest language we could find, which is they can do the investigation unless the mayor opts not to.
And Heidi, I'll just call out, Dan's got a comment in the Q&A where he says that that's the charter stuff you're referring to is about hiring and firing, not investigating misconduct.
That is true. But when you have the authority to direct the work and hire and fire, part of that is making decisions about how to investigate somebody and how you want to handle the matter. And that just, to me, as a labor and employment attorney, that just goes with a manager's authority to the people that report to that manager. They have that authority to make determinations about the investigation and how it's going to occur, along with then the final decision, the final decision of whether to discipline or not and what that discipline should be. Yeah.
That almost sounds like the police can grant immunity to the chief from being investigated by the police accountability.
You mean the
system.
mayor?
Yeah, because so as it reads, even though the charter explicitly says the board has jurisdiction over Portland Police Bureau sworn employees and supervisors thereof, 2-1001, the code allows the mayor to decide whether the system will investigate allegations of misconduct against the chief. Almost like the mayor can grant investigative immunity to the chief. That's what it sounds like.
well, I suppose that's right, I mean, ultimately, the mayor is the one who's gonna decide. Let's say the mayor said, go ahead, oversight system, investigate the chief. But at the end of the day, even if they investigate the chief, the final decision about what to do with the chief of police, if there's a sustained finding, is in the mayor's hands. And deciding whether or not it's sustained is in the mayor's hands. They have the authority to direct the work and to hire and fire them, and that includes making disciplinary decisions. I mean, I guess at the end of the day, you know, if you had something that was, the mayor said, well, I'm just not gonna investigate this, that may very well impact, their ability to get reelected. And if it's real egregious, maybe it impacts a recall, but that doesn't change that the grant of authority under the charter, which is our constitution, went to the mayor, and that the mayor has that authority to make hiring and firing decisions of the chief of police. It's two people that report to the chief of police, that report to the mayor, the chief of police, and the city attorney. Those two. And the city administrator, excuse me.
Can you scroll back up?
To the part that was highlighted before about this conversation.
Whoops, bad highlighting, but yes.
Maybe it's just my understanding and interpreting it kind of backwards of the entire conversation that's been happening right now. But is the police chief not a sworn employee?
They are.
And what you're saying is the mayor not the sworn employee's supervisor? So wouldn't this technically give the board the ability to investigate the mayor if it is involved? Does that question make sense?
I hear what you're saying. The issue here is that charter language was superseded by a new charter language that gave that authority only to the mayor.
And then for any elected official, the voters are the ones that decide whether they stay in office or not. So the city as an organization doesn't have the authority, nor does an oversight system to make a decision to remove an elected official from office. That authority doesn't exist.
It just seemed like maybe that authority was granted through the ballot.
I think originally the ballot measure, in 2020, when that ballot measure was adopted, I would read that to cover the chief. But when subsequently the new form of government amendments were made, that granted that authority directly to the mayor. And that's why, because it was very specific grant of authority to the mayor to hire and fire, and also came later in time. So that specificity in the subsequent time was what influenced that analysis. Yeah, well, but that's why our elected officials answer to all of us as voters, right? That, I mean, at the end of the day, that's the power that we all have, is to get out and vote and say whether we feel like you're doing the job we want you to do or not. If somebody's doing something, an elected official, very egregious, we have seen recall petitions out there, right? Because people feel that the conduct of an elected official is so egregious that that's what it
But
was.
why lean on that power to give that kind of authority? We have the power to write that out right now. A lot of these things that we're discussing right now. But then we're getting a lot of HR experience.
Well, if the charter hadn't changed, then we would have left that in there. But with the change in the charter, that was just from my perspective, a legal analysis of what's the authority that we can grant to this oversight system. And the most authority we could give is they can investigate the chief of police unless the mayor opts not to have that happen. That was as far as I felt legally we could go, given the way that the new charter amendments read. Because you can't adopt code that overrides charter. So nothing, we couldn't, like, for example, we couldn't adopt, let's say we wanted to in the charter, let's say council had wanted to say, this is 5% is too much money. We should have 4% or 4.5%. They can't adopt code language that changes charter language.
I'm gonna move us on.
Sorry.
I'm gonna move us on because we're down to our last 16 minutes. And so I think the next question or the next concern that was raised in the letter was with regard to the PAC's concept of undesirable outcome reviews and looking at systemic incidents rather than individual disciplinary incidents alone. Heidi, can you say a little bit about this? That's this one. Because I think this is one of the ones where we encountered some pushback from other city bureaus that are responsible for some of this work.
I'm sorry, I'm trying to read it. I was reading one of the questions in the chat about the number of board members and got distracted by that. I'm sorry, give me 1 minute. Oh, yeah, so there were recommendations in the Police Accountability Commission's code language that were outside of investigation, discipline of sworn members and supervisors thereof, and policy recommendations. And we've read the charter language to be clear. That's the mission statement that we started with, says this is what this oversight system is to do. And then there's funding attached to that the voters approved of 5%. So that funding goes to that mission. So the provisions that went outside of that mission were taken out. Folks may remember that at one point, Commissioner Rubio was considering, could Portland Street response go under the oversight system, and therefore we maybe have the funding we've been trying to figure out, luckily that we have figured out for this year anyways, and help alleviate that concern. But because the mission statement is very clear and the funding amount goes to that mission statement, we did not feel like legally we could do that. And similarly to this, that things that were outside that mission statement, we felt were not appropriate to be under the oversight system. That being said, there are many, we have other advisory committees and other advisory committees that do a lot of that work, and that and if there's something that former members of the Police Accountability Commission feel is not being done by an advisory committee, then let us know, because I think there's, PSAP, Portland Committee on Community Engaged Policing. They exist. They do a lot of great work and recommendations for changes to PPB in the city. And we have Training Advisory Committee. We've got the Coalition of Advisory Committees, which has many different community groups who come together and have somewhat of a shared vision that they want to tell to PPB, and that they do. So if there are things that you feel like we missed that would be appropriate in advisory committee, let us know, please.
All right, moving right along. My highlighting is terrible right now. So there was one concern about the fact that the code language revises the categories of findings that can happen
That's
to
me.
2. So I'll let you, Heidi.
Yeah, this was my pet peeve. So in every other discipline investigation, you analyze for, is it sustained or not sustained? So you have, in the court system, you have either you've proven it more likely than not that something happened, or you didn't meet that level of proof, or you prove it beyond a reasonable doubt, or you don't meet that level of proof. You have to come up to the level of proof. And to me, having seen this is exonerated, this is unfounded, there are currently four different findings that can be made: sustained, not sustained, unfounded, and exonerated. And to me, unfounded and exonerated are covered under not sustained. If it's not sustained, then there wasn't enough evidence to show that misconduct occurred, or maybe you had evidence that showed that it didn't happen, or that there was no basis in fact for the allegation. And just having sustained and not sustained, to me, is easier and clearer. And sometimes people get lost in one person wanting it to be exonerated, another person wanting it to be unfounded, and somebody else wanting it to be not sustained. To me, it's just cleaner to have not sustained, it includes all those things. So that was a, please can we narrow this down from Heidi Brown request? Yeah, you may. Yeah.
Yeah, I think that's right. I'll repeat that because I don't think the microphone was on. Just doing a time check and wanting to make sure that, you know, in addition to what we have here, if there are other questions that are outside of this, these concerns raised, we want to be sure to provide space for that, those questions as well. Go for it.
All right, I want to ask this because I know there's some members of the CRC who are the Citizen Review Committee who are watching. So with regards to the transition, which is a little bit less code related, but is your plan that you will first staff a coordinator to run the recruitment process? And in which case, does that mean that this will probably go to actually the new council to vote on nominations? Or is this all going to happen in 2024? And then I guess as a addendum to that, given current Office of Civic Life guidance on membership, is the intent that CRC members who also potentially will be on the nominating committee, like, are they going to need to recuse themselves from either being on CRC and also applying for the new board, and or being on the nominating committee and applying for the new board?
Those are good. The last questions about whether they can be on both are good questions. Let me look into that and get back to you all. I can think of a reason why you couldn't do both, but let me think about that for more than 5 seconds.
Okay.
And then, wait, there was something else you asked at the beginning about the timing of it.
We're planning to get this moving as quickly as possible. I think our goal is to have this board seated in 2024 and make sure that, you know, that these folks can start doing their work as soon as possible.
Did we lose the?
Oh, jeez. Oh, no.
So I'll just continue this one question.
Hang on 1 sec. I'm gonna, folks, I'm gonna return. Can you all hear us? Let's see.
Okay. Because I think I made myself a host, so.
Yeah, the only reason I asked is just because obviously we're gonna have to, CRC is gonna have to nominate nominators. So before I ask people to do that, I want to make sure they understand like what are their options as they look at the sort of the off-ramp from that. So
I think it's a really good.
we can discuss that offline though.
Yeah, I think that's a really good thing. We should have an answer on. Any other questions? Let's see, I'm trying to.
Debbie had a question. Debbie, and I saw you, I'm scrolling down and getting different things in mode, but great, you can still hear and see us. Debbie, if you or anybody else has information about why it's better to have 4 findings available to folks: exonerated, unfounded, not sustained, and sustained, rather than just the normal sustained and not sustained. I do see Dan noted it's a win-lose. And that you think that that's a better to have, not just a win-lose, but to have other options available. I appreciate that perspective. And I'll, you know, we can certainly consider that and reconsider that question. But if there's other information about why it's better to have 4 findings, please email me as well. I'd appreciate that. Thank you for that feedback.
Okay. Sorry, I think I've lost track of where we are, Heidi.
Changing the size of the
Changing the
panels
size of the
from 5 to
panels.
3, and that's in the chat as well. I think that, you know, what I can say about as we were looking at the number of members was to try to ensure that we could fill seats and get people to come and do this work. It's involved. It's a lot of work. You know, you may see her, he's a citizen review committee member and he's been on officer involved shooting cases as a CRC member on the police review board. And it can be thousands of pages of documents that you review, and as we get body camera footage, you know, sometimes we have video that we review as part of the evidence on any case. Officer involved shootings tend to be the most voluminous, but any case can have quite a bit of documentation and video footage, audio, whatever, that has to be reviewed. And you really, if you're going to be analyzing the matter, you need to read it all and listen to it all and watch it all. So it's a lot to ask of folks. And I think we wanted to ensure we could get people to be on the board. And that was one of the reasons we went down to you know, from 33. And then also similarly with the board, from the recommendation of the Police Accountability Commission from 5 down to 3 board members, same reason, just to try not to burn people out and try to get, make sure that we keep folks in that, doing this important work.
The other thing I wanted to just say is we've made, for officer involved shootings or in custody deaths, we made those reviewable by the full board so that you know, the benefit of the entire diversity of the board can consider those cases and requiring only a simple majority in the votes on those. So I think that is important when we're talking about those cases to note as well. Okay. With regard to a concern about the investigators that are employed by the board making recommendations, I think, you know, the idea here is, number one, those are the board staff. They are hired by the director that the board chooses. They are managed through the administrative rules and policies that the board and their director put together. And so this would be their staff providing, you know, conducting investigations and providing, you know, written summaries and overviews for the board to consider. Their findings are not binding on the board. The board can certainly deviate from any recommendations that the investigative staff choose. And so I think from our perspective, they're having the board's own staff make a recommendation based on their professional experiences. We did not believe that that is something that would call into question the board's independent judgment, because they are certainly not bound by the recommendations of their own staff. I know there was a concern here, an ongoing concern regarding wanting the oversight system to have its own independent legal counsel. The city code requires there's a process for any city bureau or program that wants to seek outside counsel. All bureaus are subject to that. That process is available to this board too, if something comes up that they believe independent counsel is needed for, but that is a standard citywide policy for any bureau or program.
And similarly, you know, at one point, the Police Accountability Commission, I had actually recommended they get their own outside legal counsel because I wanted you all to get, you know, just somebody that you could view as not attached to the city in any way. And so certainly, you know, the city attorney approved that. I don't know that I've ever seen a city attorney deny such a request. So I don't think it's, I can't speak on their behalf, but that's gonna be a rare occurrence for it to be denied.
I'm gonna cruise through just a couple more minutes. So this concern was that neither the officer nor the community member can attend hearings by the board. But currently, an officer can appear at a police review board hearing in certain circumstances. They do not get to appear for that entire hearing. And so the point here is that the PAC thinks that, you know, both should either be both should be allowed, a community complainant and an officer, but this is an employment law.
Yeah,
problem.
it's different. The police review board was making a recommendation to the decision maker, who's the chief. And so in this instance, the board is the decision maker. So you would have folks listening in on their process of thinking through, making a decision, and that is appropriate to have in an executive session under law, and also just to, that's different than making a recommendation to somebody. They're not recommending to themselves what they should do. They're gonna be making that decision. So we've taken out that police review board level, and sort of, that's where we put in the complainant's ability to provide some feedback before it goes to the board, because the board is actually making an initial decision about whether they believe that misconduct occurred, and then a proposed discipline if they feel it did occur.
Okay, trying to just get through as much as we possibly can here. And I see W has asked a question about when the proposed settlement agreement amendments will be available to the public. I think those are,
They're any minute now.
yeah, they're in
Just-
process of being posted, I think, on the
Yeah,
city's trending topics website. Sorry, I want to finish through the letter here. We hear you, we hear the concern with regard to having the board go to city council to expand the case types, that will be within their jurisdiction. I think, yeah, we understand that is an ongoing concern. With regard to the way that the board will have to articulate findings in its votes and its public votes, yes, that is a frustration. We get it. It is against part of the employment law framework that we have, where we cannot just name specifically every officer in every discipline case. So that is heard and acknowledged. And then finally, the concern that there has been cut out of all references of public input at hearings and council meetings. So I don't think that's accurate. I think any council meeting is always going to have the space for public input. So any appointments, any decisions that council has to make in relation to this board is always going to come with that. At the hearings, the code tries to balance out the law with regard to public meetings combined with the law regarding employee discipline. And so this is the framework, unfortunately, that we have. And I understand that frustration, but I think there certainly can be, and I think also, don't we, they will have annual meetings where they would be engaging with the public directly as well. So on other meetings, I think they can determine that on topics or things like that as well. So that cruises through this list, and I'm sorry, I know there's still some questions in the Q&A. Dan, I see your hand. Let me.
and real quickly, Faith, ADA accommodations for access to city services are always available. So yes, if there's a need for a reasonable accommodation as an applicant, absolutely those will be made. And if somebody's on the board and needs a reasonable accommodation to be able to serve and perform those essential functions, those will be provided as well.
Okay, Dan, I think you should be able to unmute now. Dan, are you there?
Oh, did you let him unmute on his phone number? Because
Oh.
he calls in, so I don't know.
Let's try that. Did that work, Dan? I think,
Hey, can you hear me now?
there we go.
Okay. Hi, Dan Handelman, he, him pronouns, member Portland Cop Watch, former member of PAC. We got information from the city attorney's office yesterday that the red line version that we reviewed very carefully was not the correct one. So I did 2.5 hours worth of work this afternoon and found a couple of more things, and I sent that to you because we didn't have time to talk together about it. I sent some of that information to you. So just, I'm going to briefly run over a couple of things that I found. One is that the section that you fixed that we thank you for about the complaint navigators actually says that it'll be at intake for a full investigation, where intake is for any kind of thing, any kind of resolution. So that should be fixed some more. I saw that you crossed out the word governing, and put advisory in when you're talking about the kind of training that the board needs. And you've made the point a number of times, this is a governing body, so I'm not quite sure why you have done that. And in the access to information section, you cut out the words or rules when you added that to law. So it appears that it used to be broader, where there was exceptions to what kind of information the board will have access to because of their nature of what they're doing. And it seems like you narrowed that down by cutting out the words or rule. So I just wanted to point out those three. There's a bunch of other stuff I also sent in. And thank you for holding this meeting.
Thank you. And you
Thank you.
emailed that to us, right?
Yes, I emailed it to you this afternoon, late
Okay,
this
thank you.
afternoon.
Okay, very much appreciate it. Any, Dory?
In this topic from other some folks, will the recording of this meeting be available?
Yes.
The
this-
question was,
the question is, will the recording of this be available for anyone who wasn't able to attend? Yes, this should be uploaded to the mayor's website. I will send it to all the people that I know to send it to, but it will be available there.
I want to take a minute to thank Yume. He has been walking around very kindly tonight with the microphone. He's just a nice person who's come as a community member to be involved in this. And he's been walking around and handing the microphone out. Thank you, Yume. He tried to get there in time for Dory's question about PISA, and right when he got there, she was done, which is why I'm laughing, because it was so nice. And it was like, oh, no. So thank you, Yume. Yeah. Well, it was very, very kind of you. Thank you.
When you become a community volunteer.
You start walking around with a microphone.
Well,
Yeah, thank you.
thank you for the conversation. It really is important. It really does make a difference. We will circle up with our folks again and share everything that we've heard tonight. We will, be doing everything we can. I think we all have a goal here that is the same, that is we want this system to work for everybody. And so I think that's very much appreciated from us. And next steps, again, just to reiterate, there is a fairness hearing in the Department of Justice settlement agreement case on August 29th. That will be the same courtroom. We'll make sure that that information is also posted publicly so that people can access that. And that will be another opportunity for folks to provide feedback and share their feelings about the code proposal with all of the parties in that case. And I think that's it. The DOJ comments email remains open. If anyone has any additional written comments to share, we will continue to monitor that as well.
I do want to say though, please get those to us as quickly as possible, because Stephanie and I need time to talk to both DOJ and to the unions if there are changes that impact both of them. We got some good feedback tonight to look over, and today is Monday.
Yeah.
So if you could get it to us by Friday, or at least by next Monday, July 22nd at the very latest, we'll need a little time to be able to consider those and then work with our partners, both at DOJ and at the unions.
Yeah, just another logistics question. Given like all this feedback, do you have a timeline of when we could see an updated draft, or is that gonna be at the hearing?
Well, 30 days before the hearing, we need to submit to Judge Simon, and then we always post publicly. That would be the Section 8 amendments, and then we'll have a link for Judge Simon to be able to see the code as well. And so at that point, absolutely. But we'll try to, if there's changes made and we have them sooner, we'll post them sooner for everyone. So
Yeah.
we'll try to get them out there as quickly as we can. I know,
Thank you.
it's 2
Yes,
weeks from
2
now,
weeks from
yeah,
now.
so I'm asking for feedback, like
Okay.
either this Friday or next Monday, because that leaves us 1 week to get those changes made, so that's why if you can get them to us sooner, that would be wonderful.
Thank you all so much. Really appreciate it. And everyone online, thank you also for your really thoughtful comments and questions. And we look forward to continuing these conversations. Thank you.
Yeah, thank you very much.